if that's can be undertaken, I think it will help keeping proceedings reasonably efficient. If people want to draw attention to particular points I'd like to make, again, that would be very helpful. Now, this is a hearing to determine whether or not consent should be granted to an application by D. Brown and R. Venning to undertake a two-lot subdivision and establish a residential building on a property in Malligans Road near Arrowtown. Again, at this point, everyone can hear clearly?
Yes.
Okay, thank you.
Commissioner, Ian Gordon for the applicants here. We've got a slight volume issue here and not everybody can hear what you're saying.
Okay.
So we might just need a moment or two to address that if we may. Okay,
that's fine. Well, we need to get that right. So, all right, we'll just take a brief adjournment on that.
You away when we're finished. Thank you.
Now, do you think the problem's at your end or ours? Must be ours, I suppose.
It's difficult to say at this stage. Perhaps if somebody else could say something, we could, perhaps Chris Hansen could say something pleasant.
Okay, that's good. I can hear you clearly, but...
Yeah.
Good morning, Ian. Can you hear me?
I can, thank you. Yeah, that's good. Let us just try and adjust the volume a little bit here so that everybody can hear it.
Where is the speaker pod for us? Just here.
Must be there.
Okay.
Yeah, webcam. You're at this end, so it must be there. Okay, how are we going now?
I think, thank you, Commissioners. I think we've got as good a volume as we're going to get.
All right, thank you very much. So I'll carry on in the meantime. So the procedure will follow through this format. It's the same as we normally undertake in a hearing. So call on the applicant to present their case first. So all the evidence has been pre-circulated. Following that, we'll hear from submitters, and I understand there is going to be some legal submissions on behalf of two of the submitters, and I think it's also a couple of other submitters will be present. Now, after that, we'll then ask council officers to comment on any matters that have been raised during the course of the hearing. And at the end, of course, the applicant can exercise a right of reply, whether that be in writing following the close of the hearing or at the hearing's ready over to you. Now, just I'm going to make a quick declaration at this point. I became aware recently that Ms. Alexandra Bartenhoff is a member of the applicant's team, and we have both attended the same church in Arrowtown. So I've made the council aware of that. If there are any concerns about that, but I don't think there necessarily should be. Now, we haven't undertaken a site visit at this stage, but we're planning to do so, I think this afternoon, aren't we?
Yes.
So I presume that is acceptable to your client?
Yes, it is, and I recommend this afternoon, given the forecast for tomorrow.
Yeah, it doesn't look too good. No, agreed. No, that sounds good. So as it would usually be the case, we'll endeavour to have a written decision out within 15 working days. And of course, there's a right of appeal to the Environment Court arising from the decision that we make. Now, just checking who's present. So at this stage, apart from the applicant and your witnesses, we've got Marie Baker Galloway representing submitters 6 and 3, Chris Hansen presenting evidence on behalf of submitters 6 and 3, and I understand we're hearing from Glenn Bartlett and Alistair Saville. The other submitters are either not appearing, or in the case of 704 Mulligan's Road, I believe that submission's been withdrawn. So that's where we're at the moment. Now, before we get underway with the applicant's cases, are there any issues anyone wants to raise?
Yes, there's one other matter, Commissioners, is the submission from Friends of Lake Hayes is withdrawn, but with support to the applicant, and their applause for efforts to address the water quality of Mill Creek appropriately. I presume you've got that letter.
Oh yes, my apologies, I hadn't mentioned that. Yes, that's correct, we have received that.
Thank you.
Okay, well, I think we're now ready to call upon you to present the applicant's case.
Thanks, Commissioners. My name's Ian Gordon. I appear with Jay McDonald for the applicants. In the room with us are the applicants, Mr. Rodney Venning and Mr. Dawn Brown. They are husband and wife, despite that use of surname. The experts also around the table are Ben Espy, Alan Hopkins, Alexandra Badenhop, and Hannah Afifi. And that's the order in which we will go to them. We've circulated some written legal submissions, which I will take you through, subject to correction always by Ms. McDonald. And we've got some numbering and typographical errors that I'll alert you to as we get to them. Is the volume loud enough for everybody to hear me?
Yes, we can hear you fine.
Good, thank you. So from the outset, we set out what the key aspects of the proposal are. They will be known to you and I won't repeat them. But at 1.2, I will summarise the key amendments that have been made to the proposal to address the submitter and or section 42A concerns. And we assert that these changes are all within the scope of the notified application. So the access way is realigned, so it is located outside of the local purpose reserve and is now wholly within the boundaries of Lot 1. On-site planting is proposed, comprising 2,000 Indigenous plants and removal of willow trees to be implemented prior to the Section 24C certification. And the willow trees are largely in the vicinity of the spring-fed ponds at the bottom of the property. And those ponds, as you will see this afternoon, Commissioners, drain into Mill Creek. And if you've read Ms. Badenhop's evidence, you'll see that from the limited sampling that's been undertaken, that the water quality from the ponds is actually generally better, slightly better than the Mill Creek water quality, and we'll come to the significance of that later. The existing dwelling on Lot 1 to have primary wastewater treatment upgraded at the time of future alteration or extension is able to be secured by a consent notice, and that's a condition that the applicant volunteers. and Mr. Hopkins will speak to that. Stormwater runoff attenuated at soak pits rather than the discharge to swales. And again, that's to capture stormwater and prevent it from entering Mill Creek, Mill Stream directly. The boundary hedging on the proposed lot 2 to be maintained to a height no less than 5 metres and no more than 7 metres. That is the boundary hedging on the sides, if you like, and I'll describe it as the saddle side to the west and the narrowway side to the east. And then adjacent to the southern boundary, which I'll describe as the Bartlett boundary, we propose that be maintained to a height of 3 to 3.5 metres. It's presently approximately 5 metres, as you'll see when you visit the site. It's also proposed that the building height be limited to 5.5 metres above a specified RL level of 427 metres, and Mr. Espy will speak to that. So those are the changes that have been made in response to concerns that have been raised, and they generally adopt all of the recommendations by the Council's landscape expert, Mr. Denny. At page 3, I refer there to servicing and infrastructure and just say that there aren't any concerns that have been raised, and then refer to the matters in contention. So we say under the heading landscape that the experts and indeed the proposed district plan itself recognise that across any landscape character unit there will not necessarily be an entirely uniform landscape character, and that there may be pockets of different character, and consideration and assessment is required at resource consent application stage. And we submit that the experts are agreed that while the Mulligan's Valley LCU1 is generally particularly open and simple with legible landforms and pastoral landscape character, the application site itself is part of a distinct heavily treated cluster of rural living land use. And you get a distinct impression of that when you drive from Coronet Peak turnoff down Mulligan's Road in that easterly direction. When you go through the simple landscape, very clean and wide open landscape forms, and then you, beyond Hunter Road, you come to this area that's heavily tree clustered, and where there is a cluster of rural living, which is quite distinct and quite different from the rest of the landscape unit. Mr. Espy will speak to that further. An issue at large between, this is my 3.3, an issue at large between the landscape experts appears to be effects on landscape character, with Mr. Denny finding effects would be moderate, yet acknowledging the rural lifestyle character and partly enclosed wooded context of the site and surrounds, which differs from other parts of the landscape character unit. And Mr. Espy discusses this in his evidence, which you'll have read, and opines there are pockets of different character across the LCUs, as is the case here, as Mr. Denny appears to recognise. Mr. Espy points out that in the landscape character unit description for Mulligan's Valley, it is recorded that there are such pockets of mostly sympathetic rural residential land use of areas of localised containment formed by vegetation. Mr. Denny's view is that the application site is in a location where planting provides containment and is not a location that contributes to a sense of open space or openness to any substantial degree across the landscape. And he says it is the woodland character that is distinct compared to the broader open pastoral spaces along the valley floor to the west and north. The established form and scale of the woodland in context of Mill Creek I consider to be the valued landscape characteristic to be maintained and enhanced, as it conceals to varying degrees the pocket of collective existing residential buildings within a broader context of a landscape that is dominated by open pastoral spaces of relatively few dwellings. And against that extract, it's not surprising that Mr. Denny recommends that the vegetation be maintained in and around the proposed subdivision, with the exception of the willows. His report acknowledges that the established framework of trees within the site offers some ability to visually absorb development without degrading landscape character of the broader pastoral landscape. And on this point, Mr. Espy is of the opinion that the experts are aligned in their opinions that the site is distinct from the overall dominant landscape character of the valley, which is an open, simple pastoral character. As such, development of the sort proposed can be absorbed within this node without affecting the character of the valley LCU as a whole. Effects will be entirely localised, says Mr. Espy. As such, Mr. Espy does not agree with Mr. Denny's assessment of effects on landscape character as moderate. You'll get a feel yourselves when you stand on the site as to how enclosed the sites are, and therefore, when looking into the sites from other parts of the valley, how well screened any development that was to occur on the new lot would be. Mr. Espy at 3.8 is another extract from his evidence, and it's worth reading. I consider that the patch report that accompanied the application, the Denny report, and myself are all in agreement on this point. The node of heavily treed rural living activity of which the site is part is distinct from the overall dominant landscape character of the valley, which is an open, simple pastoral character. This means that development of the sort proposed can be absorbed within this node without affecting the landscape character of the Elegance Valley LCU as a whole. Effects will be entirely localised. And Ms. Terhern, in her report, concluded, overall, given that, overall, given that existing mature vegetation within the site and along the site's boundaries provides considerable screening of the site from public and private views and is proposed to be protected, adverse effects in this regard are considered to be minor and acceptable. She says the site has the potential to visually absorb development due to the expanse of mature vegetation within and surrounding the site. Subject to the imposition of Mr. Denny's recommended conditions, I consider that adverse visual effects will be appropriately mitigated so to be acceptable and no more than minor. Overall, I consider that the site has capacity, albeit limited, to absorb the development, and the proposal will not compromise existing natural and Arcadian pastoral character for adjacent sites or in the wider environment. And that's the evidential crux of the applicant's case, as neatly summarised there by Ms. Terhern. And of course, we agree with you. In terms of amenity effects on adjacent properties, I'll continue with that. Notwithstanding Ms. Terhern's conclusion that the natural and Arcadian character for adjacent sites will not be compromised, her report considers that there are unacceptable adverse effects on the rural amenities of adjacent residential properties. I'm not sure whether that's still her position, but that's what it was when we approached writing these submissions. She says that's due to greater density of residential activity on site and proximity to adjacent sites. It's unclear, as I say, whether that remains her position with the adoption of Mr. Denny's recommended conditions. Turning to the RMA's definition of amenity values, it's those natural physical qualities and characteristics of an area that contribute to people's appreciation of its pleasantness, aesthetic coherence, and cultural and recreational attributes. In context, the site is located in an area that has been developed primarily as rural living properties. Case law supports the proposition that a change per se does not mean that there is an adverse effect on rural character or an effect on amenity values. And that's the Yaldhurst Quarries case that we've cited. Amenity effects on neighbours are discussed in some detail, both the evidence of Mr. Espy and Ms. Fifi. In summary, the applicant's evidence is that the standards specified in the proposed district plan for building setbacks of 10 metres are met by the proposal. Indeed, I would estimate the distance, and Mr. Hanson can give more accurate evidence about this, but I would estimate the distance from the Saville residence to the nearest edge of the proposed building platform at about 70 metres, whereas the proposed district plan suggests that stipulates 10 metres is sufficient separation between structures and boundaries in order to retain rural character. And I'll come back to that at some stage. 313B, the Savills raise issues not with visual amenity but with dust, noise and privacy. The closest part of the building platform, well, we've said it's 55, it looked like 70 to me on site, is entirely screened by dense evergreen vegetation. The existing dwelling on the application site within proposed lot 1 is 75 metres from the Saville dwelling, and the Bartlett dwelling is some 90 metres from the Saville dwelling. These separation distances are not unusual in rural living areas. Dust nuisance, if any, will be mitigated by the dense evergreen shelter belt along the common boundary to be maintained at a height in a range of 5 to 7 metres. Anecdotally, I just want to add there that when you're on the site, it's not immediately apparent where the Bartlett and Saville dwellings are, and one has to go through the shelter belt, the existing shelter belt trees, to locate them and appreciate where they're located relative to the site and the proposed building platform. In relation to the Bartlett dwelling, it's almost totally screened from the building platform, and that can be achieved with retention of the shelter belt at its current height. We've said approximately 4 metres. It looks to the naked eye to be about 5 metres now. The survey evidence from Mr. Hanson provides data as to screening at 3 metres and 5.5 metres. I addressed the Bartlett submissions below, but note that whether the height of the shelter belt is 3 metres or 3.5 metres, or between 3 and 3.5 or 5 metres, or somewhere in between, screening of the building platform is possible to achieve by way of conditions to maintain the height of the existing shelter belt. I would add that the more spectacular and panoramic views to the north, that is from the Bartlett dwelling to the slopes of the Coronet Range and the ridgeline itself, are significantly elevated above the application site and not affected by the location of the building platform on Block 2 and any building within it, or the shelter belt itself. And Mr. Espy's images demonstrate that. In relation to the submission from Mr. Narrowway and Ms. Manley, they're the owners of the property to the east that doesn't presently have a house on it. We submit that amenity effects that they've raised have been addressed by conditions to retain boundary hedging of 5 to 7 metres along the common boundary, offsetting the vehicle carriageway, and with the retention of 2 rows of established shelter belt trees. Given the topography of Block 2 and the Narrowway site, there will be no overlooking of a Block 2 dwelling to the Narrowway platform, so their privacy would be maintained. One of the issues raised is shading from the existing boundary hedge and the existing environment. So the boundary hedges planted on the application site are part of the existing environment. They're lawfully established. There are no rules in the district plan restricting the height of planting along boundaries. Boundary hedges in the Wakatipu Basin are a common landscape feature and vary in height. They function to provide shelter and privacy and contribute to Arcadian landscape values. I'm aware from a prior application lodged in respect of the application site, which we annexed to these submissions, that the boundary hedges have in the past, that is the boundary hedge to the south with the Bartlett property, have been maintained at 15 metres in height. That was in 2013, I think. The evidence of Mr. Espy is that the boundary tree species can grow to 15 to 20 metres at full natural height. It is accepted that the shelter belt located off the boundary by some 4 metres, so it's 4 metres inside the boundary is where this line of labelled cypress are. It's accepted that it shades the Bartlett driveway at times in the winter. And we submit that shading of the Bartlett driveway is not an adverse effect of the proposal before you. It is an effect as a result of the environment as it exists, and it will endure whether this consent is granted or not. There is no obligation on the applicants to maintain a shelter belt at a particular height. As submitted, it is a positive effect of the application that the applicants are offering to maintain the height of the shelter belt to reduce shading levels and offer a condition to that effect on an ongoing basis. So, in summary, it's been as high as 15 metres. It's now down to 5. The condition offered is to maintain it at 3 to 3.5 metres, and the evidence, Mr. Espy, is that that will reduce some of the shading at times and enable the visual screening of any dwelling on the new lot to be maintained. It might also improve some aspects of the view to the Coronet Range. And I haven't had a chance of reading Ms. Baker-Galloway's submissions yet, but I anticipate she'll take a different view of that, and I will address that in closing. Turning to water quality in the Lake Hayes Millstream catchment and the applicable policy framework, I referred to Mr. Hearn's Section 42A report and finding that there was insufficient information available at the time of writing to demonstrate that potential adverse effects on the water quality and ecological health of the creek and the wider Lake Hayes catchment would be appropriately avoided, remedied, and mitigated as a consequence of the proposal. And she found that it was contrary to policy 24241 and 24242. To address those concerns, the applicants have made a number of amendments which I've touched on and which are included in those I draw your attention to. The evidence in this Baden hop is that the amendments to the application addressed to improving water quality will contribute to improving water quality in the Lake Hayes catchment, commensurate with the scale, nature and location of the proposal. This in turn means the proposal is consistent with Objective 2424 and the implementing policy 24242. Again, I'm not sure where Mr. Hearn stands on that since the evidence of Ms. Baden-Hop was produced. But it's our submission that evidence is clear that the water quality can be improved through the conditions attached to this consent if granted. In particular, the planting of 2,000 indigenous plants and trees and replacing of willows on the land outside the local purpose reserve will achieve that, in her opinion. Just want to be clear on one thing about the local purpose reserve, commissioners. It's how wide is it? It's approximately
20 metres outside.
it's approximately 20 metres either side of the midpoint of the stream. It's not maintained by the council, and there is work that needs to be undertaken by the council and in conjunction with the trust set up to improve the catchment. Planting is not intended for the local purpose reserve, but for the applicant's land either side of that reserve, as I understand it. And that's correct. So that brings me to policy 24211. This is the policy in the PDP that references a requirement for an 80 hectare minimum net site area within the zone. And it's addressed by Ms. Fifi in her evidence, and she goes on to express her opinions regarding the consistency of the proposal with the policy suite falling under Objective 2421. The decisions version of the policy, and you may be familiar with this, reads, require an 80 hectare minimum net site area to be maintained within the Wakatipu Basin Rural Amenity Zone outside of the precinct. And this application site is outside the precinct. This policy and rules that flow from it have been subject to environment and High Court decisions in the context of a resource consent application. The amenity zone policy framework was also appealed to the Environment Court with a hearing conducted in December 2021, and a decision is pending. But in the Todd case, the court considered the issue of a proposal for subdivision of a site that was already less than 80 hectares, conflicting with policy 24211. Court found, and I quote from paragraph 91, the proposal seeking subdivision of a site already well less than 80 hectares in area inherently cannot accord with policy 24211. However, in the design of chapter 24, as we have discussed, that does not condemn the proposal. Rather, it allows for the proposal to be consented subject to it proving satisfactory in terms of the matters addressed in this interim decision. Paragraph 92. On that basis, we find that granting consent would not impact on the integrity of chapter 24 or the PDP as a whole. As such, it does not pose any precedent risk. And the Environment Court, I say at 322, what we say at 322, the Environment Court's application of the policy framework and its findings were upheld on appeal to the High Court in a case called Bryle, where the High Court held that the Environment Court did not fall into any error by failing to treat 24211 as a bottom line, whereby a failure to meet the minimum 80 hectare requirement constituted a bar to any further consideration of the proposal. So it's not a prohibited activity, it's not an environmental bottom line, and that's the present law in relation to that policy. And I have to concede that this is where our numbering goes awry, because you'll see that from now on we've got two paragraph 3.23s. But I've set out the relevant section from the High Court's judgment. I won't read that, other than to say I draw your attention to the 3 points that the High Court concluded with, the A, B and C that were in that quote. The site would not be adjacent to the slope hill ONF, and the proposal would protect the associated landscape values. The proposal would at least maintain the particular landscape character and amenity values of the landscape character unit, which is located. And in those and other respects, granting consent would maintain the integrity of the Chapter 24 zoning purpose. and that zone purpose of Chapter 24 is referred to at footnote 19 to maintain and enhance the character of the Wakatipu Basin. And it's our submission that this application is on all fours with the Todd case as approved by the High Court in Bryall. And that's what we say at the next paragraph, 323. You might want to call that 323B. On the strength of Todd, it is submitted that policy 24211 is but one of a number of policies sitting under Objective 24221 that need to be considered as a round, and in the event of conflict, it is not fatal to the grant of consent. And at the next paragraph, 324, which you might consider 324B, while the commissioners, while you can only consider the decisions version of policy 24211 under section 1041B, 6, it's submitted that the council's evidence presented to the Environment Court last year on the policy framework for the rural amenity zone, which is known as top of 30, is a matter that is relevant and reasonably necessary for you to take into account under 1041C of the Act. So this is really where the council has been reviewing the policy around the 80 hectare minimum as it applies to the Wakatipu Basin, and listening to the numerous appellants who were saying that it's out of all scale with the nature of land holdings in the Wakatipu Basin. And in response to those appellants, the council is effectively softening its stance. And I summarise it as such because I think that's what Mr. Barr for the council, that's what his evidence really amounts to. And he proposes a new policy 24211, which we've set out there and is worth reading. It's an avoidance policy. So it's got some strength in that regard, but it's avoiding a new residential development or subdivision for residential activity outside of the precinct that does not achieve the identified net site area standards unless the proposal A, avoids adverse cumulative effects on the landscape character and visual amenity values identified in Schedule 24.8, and B, is located and designed and of a nature that will ensure landscape capacity is not exceeded. Those amendments reflect the council's changing position to promote a modified rural amenity zone regime, where landscape character units have been identified to have moderate or higher capacity rating, and the 80 hectare minimum across the amenity zone is inappropriate. The policy will thus apply to all parts of the amenity zone where there is non-compliance with a specified density standard. That is including those areas that are rated moderate, high, or high. If the elements each of limb A and B of the proposed policy can be met, then precedent and plan integrity issues fall away. But importantly, because we're not dealing with a moderate or moderate high landscape character unit here, we're dealing with a low. In other words, LCU1 has a low ability to absorb development.
I'll just interrupt briefly there, if it's okay, because we're certainly thinking about this quite carefully. What you've described there in paragraph 325 is the council's evidence to the Environment Court on appeals against the 80 hectare, if you can call it that, the 80 hectare minimum, is that right?
That's right.
Yeah. Now, as currently worded, 24211 is like a king salmon policy. It's pretty brutal, offers very little scope for, and it's purely about density, not about design. So what you're seemingly saying here is that what has been looked at here now is it's turning it into a balancing policy.
I agree with the first part what you say, Commissioner. They're moving to something more balanced. But the court has already found that it wasn't an environmental bottom line in the terms of the King Centre. So in its present form, it wasn't an avoidance policy as such. It was simply to discourage, not avoid. So the court has already found it wasn't an environmental bottom line that couldn't be disturbed.
Well, the subdivision policy is worded like that, but 24211, as it's currently worded, certainly isn't. It's to require, I think the word require is used, we've looked it up in the dictionary. It's a pretty brutal phrase that effectively means that thou shalt achieve an 80 hectare minimum. Now the subdivision rule policy, which I think is 2.1.4,
1.3, I think.
uses the word discourage, and it then provides an exception for certain urban subdivisions.
Certain which?
Urban subdivisions. If you have a look at the wording of it.
Yeah.
I think Mr. Feeke will be familiar with that.
27.
I guess it's going to come down, we'll have to obviously look at those decisions quite carefully. One of the immediate difficulties that everybody's placed in here is that if that is correct, then the 80 hectare minimum is virtually a nullity, sort of almost a nonsense in a way, because there are practically no 80 hectare allotments in the Wakatipi Basin. If we're moving to a subdivision, or a regime similar to the ODP, which what Mr. Barr's evidence is suggesting, I guess I'm wondering what would be the point of having a minimum area, but that's something obviously that the court will need to consider, I guess.
Yes. Just bear with me one moment, please, Commissioner. So the Chapter 27 subdivision and development provisions say discourage non-compliance with minimum allotment sizes.
Then it goes on to say, however, where minimum allotment sizes are not achieved in urban areas, consideration will be given to whether adverse effects are mitigated or compensated. I'm not sure whether that's also subject to appeal. It may well be, I don't know. But yeah, again, it's in combination with being non-compliant, it still sets a pretty high bar.
Well, it's discourage, not require. And as I understand the Todd decision, the court found that it wasn't an environmental bottom line. But I can address that in more detail, perhaps in closer, because it's clearly an issue that you've thought of and is troubling you.
Okay.
And
Sorry, I think you're up to 3.26. My apologies.
yeah, no, that's all right. Don't apologise. So what I was saying was most importantly, the proposed new policy also provides a more detailed direction in relation to landscape outcomes that are considered to achieve 2421, where a non-complying activity status is triggered. And it allows for proposals to be considered in the round with the benefits of fine-grained, fulsome assessment of the site, proposal and surrounding environment. And we say that that approach is evidence from the guidance text in 24.8 on how the landscape character unit descriptions in Schedule 24.8 should be interpreted. The text provides assurance that proposals are to be assessed on a site-specific basis, rather than on reliance on landscape character units. And we've set out there what we think are the most significant sections of that text. Second paragraph is worth reading. Although the landscape character unit descriptions apply to specific areas within the Wakatipi Basin that share similar landscape or settlement pattern characteristics, they do not uniformly describe the landscape character of any unit. Across each unit, there is likely to be variation in landfall, development, and vegetative patterns, excuse me, which will require consideration and assessment through consent applications. In the third paragraph, or rather the fourth paragraph, the descriptions are based on the scale of the relevant landscape character unit and should not be taken as prescribing the values and or capacity of specific sites. The descriptions are intended to be read collectively to inform landscape decision making in the Wakatipu Basin by highlighting the important elements that are to be maintained or enhanced within certain landscape character units. And so the policy as proposed provides strong direction relative to the landscape outcomes that are to be achieved when proposals do not comply with the identified net site area standards applying to the amenity zone, and provides a pathway in our submission for appropriate proposals to be consented, of which there will be some. The policy is an improvement to the decisions version in this regard. This is Mr. Barr's policy. Importantly, linking back to Schedule 24.8, and it acknowledges the findings of the Environment Court of Todd that the failure to meet the minimum 80 hectare net site area is not a complete showstopper. And so that's where the council is moving to. It's a pity, commissioners, that the court hasn't issued its decision yet. When I last heard the judge speak about progress on that decision, he referred to February, and of course we're well advanced in February and there still is no decision. But it is what it is for the time being. Mr. Espy's evidence in our submission is particularly pertinent here, in particular that the proposal is located and designed such that it will retain the landscape character of this part of Landscape Character Unit 1, identified in Schedule 24.8, and is located and designed and of a nature that will ensure landscape capacity is not exceeded. Mr. Hearn appears to be in agreement with Mr. Espy on this aspect. So I can turn to the submitters and deal with them very briefly at this stage without hearing the evidence that arrived on us just this morning. Mill Creek Trust, all the conditions sought in the submission have been accommodated other than the provision of water pump test results. With respect to those matters raised in the email from Mr. Soundy, the evidence for the applicants is that the existing septic tank system is operating satisfactorily and is suitable for its current use. No evidence is provided of any adverse environmental effect that would warrant upgrading the system as part of the approval to this application. But as I've mentioned above, the applicants have offered a consent notice condition to require an upgrade in the event of any future alteration or extension to the dwelling. That's the existing dwelling. Mr. Soundy for the Trust requests an encumbrance to secure obligations to screen the boundary planting at the height proposed. An encumbrance is not necessary and is the wrong tool in our submission. The consent notice conditions that have been offered in this regard are the appropriate mechanism to secure the obligations to maintain the height of boundary plantings. What we said when we wrote these submissions was the saddles have presented no evidence in support of their submission. And there is evidence that we've received this morning. And when one compares the notice of hearing information that's gone out to the applicant and to the submitters, you'll see that there is some difference in that the notice that we received said that all evidence had to be received by Friday a week ago, and the notice that went out to the submitters simply referred to expert evidence having been received Friday a week ago. So we were somewhat surprised to see that other evidence arrived this morning. So that's why the first sentence reads as it does. Nonetheless, we say that the concerns raised in the submission that was originally received from the Savills have offered conditions securing boundary hedge planting heights between 5 and 7 metres, reduction of building height limit on lot 2, and a curtilage area to restrain activities beyond that curtilage. And as I've said, the distance between the nearest edge of Saville dwelling and the closest edge of the proposed building platform is 55 metres, when in order to maintain rural amenity, the proposed plan says 10 metres is enough. Nonetheless, when you stand on the site, which perhaps you haven't done yet, Ms. Baker Galloway, you can't see the Saville house because it's completely screened by plantings on both properties. One has to go through the screen planting and find a location in the fence line to appreciate where that dwelling is relative to the proposed building platform. Those kinds of separation distances are fairly typical in nodes of rural residential living in the Wakatipi Basin. Friends of Lake Hayes Society, I've referred to their withdrawal of their submission and their support for the application. The submission from Mr. Narraway and Ms. Manley is complied with in terms of the conditions now offered. The carriageway has been moved out of the local purpose reserve. The boundary hedging is to be maintained and maintained at a height of no less than 5 metres and no more than 7 metres. The setback to the closest edge to the carriageway has been increased from approximately 2 metres to 7.25 metres, and both rows of boundary trees are to be maintained. The ORC submission seemed to be a desktop approach, and we simply say the applicant's expert evidence has addressed the matters of concern that the ORC raised. In relation to the Bartlett submission, again, we didn't have the evidence that has now arrived, but we had Mr. Hansen's evidence, which has been pre-circulated, and he has, as you know, addressed the visibility of the building platform when the screen shelter belt is at 5.5 metres, 3 metres, and that evidence also illustrates the extent of shading to the Bartlett driveway from the shelter belt measured again with the shelter belt at 5.5 and 3 metres. And while Mr. Espy will speak further to his evidence and the survey information provided by Mr. Hansen, the applicant, in proposing a reduced shelter belt height of 3 to 3.5 metres, has endeavoured to address both of Mr. Bartlett's concerns with respect to shading his driveway and screening of views to any new building on lot 2. The evidence for the applicants is that effects on the Bartlett property and its amenity have been appropriately addressed and avoided, remedied or mitigated. The applicants offer an enduring consent notice to maintain the shelter belt at a height of 3 to 3.5 metres, and we submit it's a positive effect of the proposal when judged against the existing environment. Next sentence should read, if Mr. Bartlett seeks to have the hedge maintained to a different height than offered by the applicant, then the applicant is open to considering that. And can I say that that extends to the macrocarpet pines slightly further to the west along that boundary as well. In other words, if there's a desire to have those at the same height as the Leyland cypress hedge, then we're happy to see a condition imposed to that effect, and that might improve some of the panoramic views to Coronet Peak from some locations on the Bartlett property. In my submission, the panel that should read needs to bear in mind that the more panoramic and primary views from the Bartlett property to the Coronet Peak skyline, which will not be diminished by small-scale glimpses of a dwelling through a shelter belt, even if there are those glimpses, and indeed the plantings on submitter's own property. In this regard, the applicants offer to keep, and it should read and to maintain, the shelter belt at 3 to 3.5 metres is a further positive effect in maintaining views to this wider panorama. The photographs attached to Mr. Espy's evidence, he'll take you there, but I simply say, Commissioners, that they're worth thinking about, and perhaps if you can find those places that he took those photographs when you're on site, you'll have a better appreciation of what I'm advancing, which is that it's quite an enclosed site, but with fantastic view of the Coronet Range above the vegetation. And nothing that is proposed in this application causes any detriment to that panoramic view in our submission and Mr. Espy's evidence. The other submitter remaining, Malian 704, has withdrawn their submission. And for that reason, there's no adverse effects on the submitter that can be regarded as more than minor. Turning to the conditions that I've mentioned probably ad nauseum, Appendix B to Ms. Afifi's evidence sets out a comprehensive explanation of changes to conditions from those proposed and recorded in the Section 42A report, and a full set of updated conditions incorporating the changes that have been made. Those changes are explained in her evidence and should be clear, but she's happy to take you through those as may be appropriate or required. On precedent and plan integrity, we say that this has been alluded to in relation to the Todd case and the amended policy 24211 promoted by the Council in the Topic 30 hearing. The evidence for the applicants is that a grant of consent to this proposal will retain the landscape character of this part of Landscape Character Unit 1, identified in Schedule 24.8, and is located, designed, and of a nature, excuse me, which will ensure landscape capacity is not exceeded. And as such, granting consent would not impact on the integrity of Chapter 24 or the PDP as a whole. And when you stand on the site, hopefully this afternoon, Commissioners, hopefully you'll be impressed by what struck me is that the site is incredibly well contained from the existing neighbours in the way that the existing dwellings are all contained within their own boundary tree planting. It's almost a logical plateau, if you like, within that contained landscape for another dwelling or structure to be located. And I know that Mr. Bartlett and Mr. Saville have views about that because they don't want their immediate environment to change. But our submission to you is that there will be no realistic impact on the amenities that their properties presently enjoy. And in that respect, and in the other respects that we've submitted, the effects on the environment will be no more than minor. So in relation to Section 104D, it's the evidence for the appellant that both threshold tests under 104D are met, and there is jurisdiction to therefore go to Section 104 and grant, excuse me, 104.1 and grant consent to this application, and it's submitted that the application is deserving of consent under the Act. And finally, Commissioners, although the RMA is under review, presently is still an enabling piece of legislation, and enabling this application has positive benefits in terms of providing another opportunity for someone to live in the Wakatipu Basin without causing any adverse environmental effects. So those are the submissions, the opening submissions in support of the application. And if you've got any questions, I'd be happy to take them now, or we can simply go to the first of our expert witnesses.
Thank you.
Yeah, thanks, Mr. Gordon. I do have a couple of questions. The first one is relating to the interim decision of Todd and comparing that against the Wakatipu Basin Chapter 24 zone purpose. In the Todd decision, the court in paragraph 18, they refer to the zone purpose seeking to maintain and enhance. Yet when I printed off the latest version of Chapter 24, which mine was dated October 2021, the zone purpose seems to have changed to maintain or enhance. And I just wondered, do you know anything about that change and when that happened?
We noticed that too, Commissioner, and we don't know anything about the background to that. We assume that the court actually has made a typographical error in recording it incorrectly. But we're happy to make some inquiries about that.
Yes, because I see that as quite different things, maintaining and enhancing or enhancing. So yeah, I would appreciate some information on that. The other questions I had were just, you might not be the person to ask, but if you could just direct me to them at the right time, was about all the water quality, not so much questions on the detail of it now, because that seems to, well, at the moment, be quite aligned, but it was in terms of how it's going to be monitored, how it's going to be maybe when's it occurring and whereabouts it is going to be on site. I'm sort of lacking detail on those sort of practical things.
You and me both, Commissioner, but Alexandra Bainhoff is able to speak to that. Have we got any monitoring conditions here?
Consent notice conditions for the maintenance of the flats.
No, the monitoring of the water quality. Right. So that may be a gap in the conditions, Commissioner. So Ms. Badenhoff's evidence establishes that the planting will improve the water quality, but there hasn't been any monitoring condition volunteered. But we're happy to do that.
That would, right. Okay, well, I'll look forward to getting that. It just sort of would close the gap between having a report which says all these great things and then making sure it actually happens out on site. And the other question I had was, you mentioned this, is it topic 30? The decision is almost coming in February at some stage. Is there any merit for the applicant in waiting for that to be released before we consider?
I was just going to ask that question as well.
If it's so close?
It's a question that's troubled me as well, Commissioners. And I think I can disguise this. I put that to my clients and suggested that we'd all be assisted by some delay in that respect, and particularly you would be. Sadly, Mr. Venning is terminally ill and is fortunately, very fortunately, has lived beyond his oncologist's expectations. So his instructions, not surprisingly, were to get on with it. Now that doesn't really answer your question. And I suppose I would say to you, if you decide you need to double the time to give a decision to enable that decision of the courts to come out, then that would be perfectly understandable and quite reasonable.
Yes, I think, Mr. Gordon, we're all finding ourselves in a position not of our own making, one that we'd prefer not to be in. And I think my colleague's question there, the difficulty is you mentioned you made reference to the evidence of Mr. Barr to the hearing.
Yep.
It's the words of a song that say, love changes everything. Well, in this case, Mr. Barr's evidence would change everything for your client if that's the direction that council is prepared to concede. So it's very difficult. So I'm not sure the difficulty we face is that that's his evidence to the hearing and we can't put any weight on it, unfortunately. That's the difficulty we're in here. We've got policies that, as currently worded, are a little bit like tablets and stone in a way. So we are in that difficulty. So, yeah, I appreciate you. I can't expect you to have a magic solution to it, but it certainly puts us on the horns of a dilemma.
I appreciate that, Commissioner. It is a difficult position for you to be in, but I did say that it's a section 104(1)(c) matter. In other words, an additional matter that you can take into account. And remembering that Mr. Barr gave that evidence on behalf of the council in a public hearing as on the basis that it was the council's now expressed view in response to the appeals. Now, you don't know what the court's going to make of that. Those of us that have had dealings with the court in relation to settling appeals are of the view that the court received that evidence well. In other words, the court's been troubled by these appeals saying that the 80 hectare minimum is a problem, and it was open to suggestions to compromise. And that's where, that's the context of Mr. Barr's evidence given in that public forum.
Yes, I understand.
I can't take it any further than that. And as I say, it's a 104(1)(c) matter until that decision comes out.
Okay, thank you.
Commissioners, I just thought I might be able to answer Commissioner Sinclair's question about the change in the zone standard with the or and. So the Todd decision was heard in June 2020 and a decision issued December 2020. And that and was the terminology used in the zone statement as the provisions read at that time. You'll see that attached to the section 42A report is a consent order of the Environment Court issued on the 27th of July last year, and that shows that the and has been deleted and replaced with or. So that we are now dealing with a zone statement that talks about maintain or enhance.
Thank you, Mr. Donald.
Thank you.
I just had two further follow-up questions. Well, not from Ms. McDonald, but just from your legal submissions. You mentioned that there was a trust, something to do with the Lake Hayes Local Purpose Reserve. Is that an applicant trust, or is that the wider trust that is looking after the reserve?
The reference is to the Manatahuna Charitable Trust, which is currently working on the Lake Hayes vision.
Okay.
The area under a DOC, Jobs for Nature program.
Okay, thank you for that. And the second one, I just needed to know, I didn't quite understand where the macrocarpa tree was that you were talking about, perhaps maintaining it to a certain height. Is that close to the boundary? Or I'm not sure actually where it is. I won't assume where it was.
Yes, I think there's a plan.
Will it be evident when we go out on site?
It will be. So when you're on site, you'll see a stile over a fence. It's not a boundary fence. It's just a fence in the alignment of the leyland cypress between the proposed lot 2 and the Bartlett residence. And when you cross that stile and look down the line to the east of the leyland cypress, you can get an appreciation of their height relative to the Bartlett dwelling. If you turn around 180 degrees to the west, you'll see that the leyland cypress give way to several macrocarpa, roughly along the same alignment.
Okay, and is that style you refer to in Mr. Espy's evidence by the swing set?
Yes.
Okay, I think we can find it then.
Yeah, we'll find that.
Thank you. That was all I had, Mr. Gordon.
At this stage, I only have one other question. It's a bit unrelated to that. You made mention before of the evidence on behalf of submitters 6 and 3, and that of Mr. Hanson. I haven't seen it either. I'm not sure whether it is purporting to be expert evidence or not. If it is expert evidence, then it's supposed to be pre-circulated. I haven't been advised it hasn't been, but
No, I don't take.
What's your opinion, or do you have any objection to it? That's what I'm asking.
Oh, well, no, I don't have any objection to it because the notice received by Ms. Baker Galloway's clients was different to the notice that we received. The notice we received simply said all evidence by last Friday, that is Friday a week ago. The notice that she received was only expert evidence by then. And I think Mr. Hanson's evidence met that time frame. And that the evidence of Mr. Saville and Mr. Bartlett is non-expert evidence of a residential anecdotal type. So we can't have any objection to that. It's simply, that's why I was, we prepared our legal submissions over the weekend or Friday and over the weekend, and we didn't know that there was additional evidence. So just trying to clear up the way that was expressed. But there can't be any objection to that.
That's fine. I just wanted to get your position on it. Let's clarify that.
It just means that we weren't as well informed about their position when we opened our case as we might have been.
Yeah, understood. Thank you.
Might be deliberate.
Yes.
Okay, Mr. Gordon, I think at this point, I presume you're going to want to go and call your first witness. Looking at the time, our thoughts at this stage are to hear from your first witness and then we'll take a break. It would seem to be a good time to do that. So who do you want to put up the bat first?
The opening batsman is Mr. Espy.
Okay.
On landscape matters, and he'll speak to his conclusions and respond to any questions you have in the way that you outlined at the start of the hearing.
Thank you, Commissioner. I was just going to take you briefly to a couple of parts of my evidence just to summarise where things are up to landscape-wise. Obviously, Mr. Gordon's been through a lot of the issues already. firstly, I was going to go to paragraph 4 of my evidence, which just sets out the various bits of landscape work that have been done in relation to this application. So we've got the application itself included a landscape assessment report by Steve Skelton of Patch, and that was submitted with the application. Then we had a peer review of that report by Mr. Denny, and then we had 2 memos from Mr. Denny after his peer review, which were responding to various bits of amendment to the application. So he had a memo on the 30th of June and one on the 20th of August. His 20th of August one includes his most recent recommended conditions. And so those are the conditions that have been adopted by the applicant that Mr. Gordon was talking about. Then after Mr. Denny's memos, obviously we've got my evidence that was circulated, as well as Ms. Barton's evidence to do with ecology and water quality. I was then going to go briefly to my conclusions. Excuse me. So, in summary and in my conclusion, I agree with the findings of the Patch report and with much of the Denny report and memos. The consent notice conditions that are recommended by the Denny report and memos are agreed to and adopted by the applicant. Now, one exception to that is the one that we've heard about already, which is to do with the height of the hedge close to the Bartlett property. So the application is that there is a maintenance height of between 3 and 3.5 metres for that hedge, whereas Mr. Denny was recommending 5 to 7 metres. So, given the amendments that have been made to the application and the adoption of those conditions, I do not consider that the amenity values enjoyed by neighbours will be adversely affected in a way that is unanticipated by the relevant PDP provisions. The LCU1 description in Schedule 24.8 acknowledges that rural living activity exists in this landscape parent unit, including in the form of nodes or pockets. In this context, the very minimal effects of the proposal in terms of visual change and the presence of human occupation will constitute the maintenance of amenity, in my opinion. The only other thing I was proposing to do, Commissioners, was quickly take you through my photographs, which were appended to my evidence. On the first page of my photographs, there's an inset which shows the location from which the photographs were taken. So there's a red 1, 2, 3, and 4 there. Number 4 is on the proposed building platform, in the centre of the proposed building platform. And then 1, 2, and 3 are within the Bartlett property. So photograph 1A is from the location of number 1. And that's looking towards the building platform, the proposed building platform. And you can see in that photograph the style on the fence that we were talking about. And you can also see close to that style, you can see one of the building profile poles. That's one of the back building profile poles of the proposed platform. Now, I should say these poles were depicting the originally proposed building envelope height, which has been amended a wee bit since then. And photograph 1B, which is from the same viewpoint, the same location, but it's looking really down the Bartlett driveway. You can see the boundary hedge there, which is 4 metres inside the applicant property, and you can see the Bartlett driveway heading away from the viewer. And also in this photograph, you can see the skyline. Most of my photographs, of course, are focused on the proposed building platform, so they're looking in a downward direction, really towards the proposed building platform. Whereas in that photograph 1B, you can see the skyline itself, which is the skyline that runs from Brow Peak right along through Coronet Peak and to Mount Dewar as well. So there's that skyline the whole way along. Photograph 2, as I say, you can't see the skyline there because I'm looking down towards the building platform. But photograph 2 is from an outside deck on the Bartlett property. And through the various foreground trees, you can see the boundary hedge. And beyond that is the building platform. You can't see any building poles in that photograph, nor can you see them in photograph 1B.
And do we take it from that, Mr. Eastley, that you can't see the building profile poles from the vicinity in which you took that photograph? And what I'm trying to get at there is that you didn't deliberately, or did you deliberately avoid locations where you could see the building profile pole?
Well, no, I didn't deliberately position myself in a spot where you couldn't see them. From that general location, the hedge, I couldn't see the poles because of the hedge. And then we move on to my photograph 3, which is on the sort of front veranda of the Bartlett house, looking towards the building platform. Again, the foreground trees are the main thing, obviously, and then beyond that is the boundary hedge. And then beyond that, again, if I was to look up a little bit, that photograph is the skyline of the mountain range running along the way to the north. And then in photograph 4, I'm standing in the middle of the building platform, looking back towards the Bartlett property. And you can see there the boundary hedge, and beyond that somewhere is the Bartlett house. You can't see it, although you can see, if you look closely, the brown colour of the leaves on the big oak tree that you can see in photograph 3. So that oak tree is in front of the Bartlett house, and you can see the leaves of it there in photograph 4. Having said that, you know, in my evidence, I think I say, from my site visit and from my photographs, it appears that the hedge at its current height is screening the poles, and certainly that was my experience. But having said that, I accept the evidence of Mr. Hanson, who obviously has done a detailed mathematical calculations based on survey drone data. So I'm not saying he's done that wrongly. I'm just saying my experience was that the poles couldn't be seen from those particular points I was at. I accept that possibly some corners of the upper part of the building platform could be seen. Well, as we know, that depends on the height of that boundary hedge.
What's the main, in your opinion, Mr. Eastley, what's the main visual amenity experienced when you're standing on the Bartlett property?
Well, it depends where you are, but certainly if you're close to the house of the Bartlett property, that it appears to me that the house and the decks have been configured to take in that view to the north, and obviously to receive sun, but to take in that view to the north up to the skyline of Coronet Peak and Brow Peak and Mount Jewett.
So, Commissioners, are there any questions of Mr. Eastley?
Any questions?
I do, thanks, Mr. Eastley. Just looking at photograph 1A, the lower part of the building platform is quite visible, which to me would mean that the lower part of the building would be quite visible. Can you just tell me what's proposed? Is there anything proposed there to fill those gaps in?
Well, in my understanding, there isn't. But in order to get to that view, that viewpoint is practically on the boundary of the Bartlett property.
Okay.
Certainly, if you walk to the boundary of the Bartlett property and you look under the trees, you'll see parts of a building. Having said that, a future building inside the proposed building platform is subject to some standards in the district plan, and generally is subject to domestic landscaping that people do around their houses. So it depends on the details of that, I suppose.
And the location of a dwelling within the building platform itself. So there may not be a house where that profile pole is.
Yeah, well, that's right. The proposed building platform is 1,000 square metres, whereas there's a standard in the plan, of course, that a footprint maximum of 500 square metres, and even a 500 square metre footprint is an extremely large house. So often a house will be 250 to 300 square metres, so we'll take up maybe a third of that platform.
Thank you. The next question as I have was just going through, trying to understand the rationale of why because originally I understood consent was sought for the dwelling to go on the platform, and that has since been removed from the application. Are you aware of the rationale behind that decision?
No.
Ms. Afifi will be able to answer that question, Commissioner, if you'd like that answer now or later when she's given evidence.
If I remember to ask it, I'll write that down. Thanks. Okay, the next one is just a couple of clarification points. On the northern boundary with Milligan's Road, the screening is all in place, I understand, but there's been some issues raised about what's actually on site and what's actually on road reserve. Is the current plans that we have up to date detailed enough to understand what can be legally considered mitigation and what's actually out on the road reserve?
Yes, in my understanding, they can. I'm looking at the plan, which is the second page of Appendix 1 to my evidence. And you can see there that you can see the road boundary.
Yes.
And you can see Hawthorn in the road reserve.
Yes.
And then there's Lawson Cypress inside the site itself.
Okay.
Mainland Cypress. That's my understanding of it.
Okay, so we can have some confidence with that one. Thanks. The other one is with the recent approval of the biking trail through the local purpose reserve. Do you know exactly where that is in the vicinity of the site? Both Commissioner Nixon and myself were involved with that, but I just might need a bit of refresh. Specifically, is it on which side of the creek is actually on? Do you know?
Yes, to be honest, I'm not 100% sure. I think that has changed which side of the creek it's on, so I'd have to check that.
Okay, yeah, I would appreciate that. The next one is I just want to make sure I understand when you're on the local purpose reserve and let's pretend the trail has been constructed. When I'm on the trail, it's not considered a public place, but if I was to stand off the trail and be in the reserve, that is then considered a public place. Is that my correct understanding?
No, I think it's all a public place because the trail being formed through there is being formed on public land, not on an easement. So I think the whole thing is public place.
Well, that's a question. Since that question has been raised, it might be something the officers would like to take a note of and comment on later, because like Ms. Sinclair, my understanding was that I suspect there was a bit of horse trading when people agreed to have access across their land originally in creating this reserve, is that they didn't want a restriction on future building development, and there was a rule put in the plan or a qualification to a rule saying it wouldn't be treated as a public place for the purposes of situations like this. But that's the council officers, if they could take a note of that and advise us accordingly.
It is a public purpose reserve rather than an easement. And that's 20 metres either side of the midpoint of the stream.
My next question relates to the Coronet Forest and the visibility from Coronet Forest. Do you have any knowledge on what's the future use of that land?
Yeah, I understand it's currently being felled, and I understand there's a long-term plan to revegetate that land over a long period. But other than that, I don't know.
And I think I about know the answer now, but it was just about where these 2,000 plants are going to be planted, because they don't seem to be shown on any of the patch landscape plans. and I take it there, you don't seem to have updated your own landscape plan. And is that the information that we will get at some stage, just where they are to be located, and if it's going to be part of the approved landscaping plan?
Yes, you're right there. These plans don't show that information. That vegetation work has come from Ms. Badenhop's work to do with water quality and willow removal. As I understand, most, if not all, of that vegetation work is going to be done in what you can see there is section 6, which is the willow and ponds area closest to Milligan's Road. But these plans don't attempt to show that, and there are different conditions relating to that vegetation work as relate to these plans.
Okay, but we will perhaps get a plan at some stage, or is that just going to be proposed in the conditions that it gets certified as part of a certification process through the conditions? Is that what the?
In my understanding, there are conditions proposed about that information. Information to do with that vegetation work will have to be submitted in accordance with the conditions, is my understanding.
Okay, thank you.
Provide a plan to identify the location of where that planting is intended to go. Again, Ms. Afifi can speak to that.
Thank you. And I just had couple more questions. You refer to your key list of key matters, Mr. SB, in your evidence, and I just wondered, where is it? There was one that I just wondered if one of the key matters was also lighting. And I just wondered if you had not included it for a reason, or should it be included as a key matter to consider? It's one of the objectives and policies.
Yes, in my understanding, Mr. Denny proposed some conditions to do with that, and those have been adopted by the applicant from memory. Yeah.
Okay, thanks. And I had some questions around sort of typical lot sizes in the area, and I just wondered, the plan that I have, I was looking off the aerial, it didn't seem to have the lot sizes, and I was just wondering if you knew reasonably easily what some of the lot sizes were around this pocket that you refer to.
Yeah, to be honest, I'd have to check that. Yeah, as we've heard, there's this instance of rural living that is a result of historic subdivision. But no, I'd have to check those lot sizes to see what they are.
Okay, thank you. And just on that note of rural living, in your paragraph 33, you set out the separation distances that they're not unusual for rural living areas. In your use of that word rural living, are you referring just to the sort of the context that's actually on site, but you're not referring to the rural living sort of zonings of the plan?
Yeah, you're correct. I'm not referring to rural living zonings of the plan. I'm just referring to rural living as a general term.
Okay, thank you. And just one question, the submitters raise dust as an amenity effect, and it's just something that Commissioner Nixon and I'll have to consider. If there was some sort of, and it'll be a question for the engineers, if there was some sort of treatment applied every now and then to that road, would that generate any landscape effects that you would be concerned with?
Some sort of dust suppression treatment?
Yes.
No, wouldn't.
Oh, and the last question I had was just referring to assessment matters of the plan, which I think from the ODP sort of still encourage no further subdivision and development clauses for an applicant to consider. Is that something that you would support on the more sensitive parts of the site?
Well, it's hard to see how further subdivision could be done within the amenity zoning zone. I mean, I suppose for me that comes down to an argument about mechanisms and whether it should be some sort of mechanism associated with the title, or whether the district plan should be the tool through which those things are governed. To be honest, I'm always a bit ambivalent about that. I can't see how another subdivision application could really fit in here, but that's guessing into the future. I'd rather not do that. You know, I think really the community has to be able to have faith in the district plan as the instrument that regulates environmental effects, rather than instruments on people's titles.
Thank you, that was all I had.
Yes, just a couple of quick questions. Just going to the issue of my colleague asked about lot sizes. Again, I'll take the option to speak aloud and suggest that the council officers could provide perhaps cadastral information of this cluster in the area immediately to the east towards Millbrook for us to, which shows lot sizes. I think that would be helpful, because on the face of it, this new lot, which I think is lot 2, 1 hectare, the surrounding lots did look bigger than that. So 1 hectare is taking the minimum lot size down to a fairly low level, even by the standards of this area, on the face of it. But again, we'd like to see some clarification on that later. Also related to that, and going back to the one of the matters that's been raised in support of the application is the fact that this is a cluster which is distinguished from the rest of LCU 1. But that said, there are many very small allotments throughout the Wakatipu Basin, which are less than, every one of them is probably less than 80 hectares, but I imagine many of them will be 2, 3, 4 hectares as a result of applications approved. So on the basis of that, it would be relatively easy for future applicants to argue much the same argument by saying, well, I'm surrounded by 3 or 4 3-hectare lots, so if I screen my property, I should be able to have a subdivision for a 3 or 4 hectare lot. I'm just wondering if that's sort of opening the door rather wide for, well, that particular argument opens the door rather wide to others.
To neighbouring lots, you mean?
Yeah, using that as your yardstick.
Well, I mean, I don't really use the lot size as the yardstick. You know, I think the effects are the yardstick. In the case of proposed lot 2, this subdivision could have been drawn in a way that makes lot 2 bigger, but I don't see any benefit in doing that. The boundary's been drawn to follow the escarpment and to keep lot 2 as a contained lot that takes in this terrace. I don't think making it bigger for the sake of making it bigger would help. And the same applies to neighbouring lots. I don't see the lot size itself as a key factor.
Mm. Yeah, and I guess that's the basis of a lot of the appeals against the 80 hectare provision, is that kind of approach, isn't it?
Yes, I suppose that's right.
Yeah, okay. Now, the new lot, which is lot 2, is not proposed to have planting along its northern boundary. Because one of the things that often occurs to me is that once you get down to very small lot sizes, people seek to mitigate effects by having planting along the boundary, it could create a wee bit of a sort of like a Normandy hedgerow type effect, which could be future owners could find that claustrophobic if it obstructs their views. Now, can you confirm that for lot 2, their views out towards Coronet Peak are not going to be obstructed by any proposed planting? At least it doesn't appear to be.
Yes, that's right. And Mr. Deddy, in his recommended condition, sought another clump of planting close to or on the boundary between lot 1 and 2, and that's been accepted. Really, the separation between lot 1 and lot 2 here is created by landform and elevation.
Yes.
There's quite a difference there, so it's not reliant on planting.
Okay, thank you.
No.
No, thank you, Mr. Espy. That's very helpful.
Thank you.
So what I'd like to do now is take a break of about 10 minutes. So we'll just adjourn for that period of time. Thank you.
Write down.
Hey, Danielle.
Yes.
Oh, yeah, I can hear you there. Hey, I got to shoot away by 4. Is there any way we can maybe, if we get a choice to, order of events, that you could put me up first or early?
Yeah, okay, that's all good.
Just realised I've got my headphones on and they're not plugged in. Was wondering why you
No,
didn't.
that's all good. So
Okay, thanks. If you could swing that, that'd be great.
okay, yep, cool.
You didn't want me to look into any of that cadastral survey stuff, did you? It wasn't going to come my way.
So, Steve, this isn't, so everyone's listening and when you're on mute, I think.
Yes.
Yeah. So what were you looking at?
Oh, well, we can talk later. No worries. All good.
Okay.
Okay, can everyone hear? We're ready to proceed again?
Yes, thank you.
Yep. So if you'd like to call your next witness.
Yes, thank you, Commissioner. In the hot seat is Mr. Hopkins, who gives engineering evidence, and he is ready to go.
Thank you, Commissioners. I will just jump around slightly on my evidence. I won't go straight to my conclusions. I will just touch on one or two paragraphs that I think are helpful to address some of the submissions and a few of the questions I suspect have been raised or may be raised. I will just go to paragraph 15 of my evidence, if we could. And that just looks at the impact of the proposed water supply on the local aquifer.
Sorry, Mr. Hopkins, which paragraph?
Paragraph 15.
15. Is it 1.5?
1.5.
Right. Thank you.
I've just stated in my evidence, the potential impact on the increased water demand from the bore resulting in significant drawdown and potential impact on the water table has been raised as a potential concern by submitters. As indicated within my infrastructure report, I note that the proposed additional allotment supply will not increase the bore pump rate, but will rather increase the duration of the pumping. At the required pump rate, the peak daily pumping duration will increase from 22 minutes a day for the current single dwelling to 44 minutes a day for both future dwellings / allotments. Mr. Hewland, the council's engineer, has addressed the drawdown and aquifer impact within his council engineering report and confirms that, to his knowledge, there is no pressure on the aquifer and the proposed reconfiguration to pump to header tanks will not impact on the recharge rate beyond the existing situation. In this regard, I've discussed the matter with Mr. Graham Stewart of South Drill. Now, if anyone knows Mr. Stewart, they'll know he has a vast experience in the district, and if there's anyone who can be considered an expert on aquifers and pumping in the district, it would be Mr. Stewart. Mr. Stewart has confirmed the minor increase in demand would be unlikely to result in adverse impacts on the aquifer due to the high discharge rates in this location, the high recharge rates in this location. Now, I've just pointed out those paragraphs because I know that it was a matter raised by a number of submitters. Talking with Mr. Stewart, his take on it was very much that aquifer has a very high recharge rate, and given the volumes we're talking here, there really is no issue for concern, etc. I'll now push ahead to paragraph 41 of my evidence. This is in relation to the attenuation and treatment of stormwater from the proposed access way. In this regard, I've said, overall, I'm satisfied that it is feasible to design a suitable system to attenuate and treat runoff from the Lot 2 access to an appropriate level. The detailed design of the system should be ensured through a relevant consent condition of consent. To ensure that appropriate attenuation and treatment is provided, the applicant volunteers that condition 11B4 of the draft suite of conditions is amended to include a specific requirement that the new access road runoff flows to Mill Creek, attenuate flows to pre-development levels, and treat flows by either of two options. What I would say about the condition that has been proposed or volunteered is that I note that it should probably include the wording where practical when it comes to treatment. I do note in this case, we may have one or two very short areas where due to gravity, we cannot actually treat those flows before they go into the creek. These will be very short areas, very close to the creek. And it really is not practical to expect that those areas would be able to go through any kind of treatment product, etc., proprietary device for entering the creek. So I would request that that condition include the wording where practical, only for those particular situations. I now push on to my conclusions, which I've reviewed and agreed with the finding of Mr. Hewlin's Council Engineering Assessment Report. The consent conditions recommended by Mr. Hewlin are agreed to by the applicant, apart from condition 11B4, where alternative wording has been volunteered. I've reviewed and agreed to the relevant sections of the E3 Scientific Water Quality Improvement Plan, noting that I'm satisfied that stormwater runoff from the proposed access can feasibly be attenuated and treated to a suitable level. I've given further consideration to the impacts that the proposed subdivision could have on the local aquifer, and I remain satisfied that any impact will be negligible in this regard. To address any concerns related to wastewater quality from the existing dwelling on the site, the applicant volunteers a consent notice condition on lot 1 that requires, at the time the existing dwelling is altered or extended, a minimum secondary wastewater treatment disposal system will be installed. To achieve the required level of stormwater runoff treatment and attenuation prior to stormwater flows entering Mill Creek, the applicant volunteers that condition 11B4 of the draft suite of conditions is updated as appropriate. So those are my conclusions. I will add to that just to assist Commissioner Sinclair with her question around dust suppression from the access way as far as options available in that regard. Generally, the most reliable option in these particular situations where we have relatively low vehicle movement numbers, etc., is having a good clean gravel surface with minimum fines that is renewed periodically to ensure that the fines and the dust is limited. There are other options open that are used in the industry. There is emulsions and polymer sprays that can be applied to suppress dust. These have been shown to be environmentally friendly, etc. These sort of sprays are generally used for mining activities, construction roads, and the like. They break down relatively quickly and probably wouldn't be suitable in this case due to their limited life expectancy, etc. Other options available include stabilization, lime stabilization, etc. Again, a relatively serious approach for a road that would take a limited number of movements and hardly any heavy truck movements, etc. While that could be used, I would also have concerns with possible environmental effects of using lime, etc., close to waterways. My recommendation in this regard would be that the simplest approach would be ensuring a good clean gravel surface is maintained in perpetuity on that access way, and it's not allowed to be contaminated with fines over time. So that would be my recommendation in that regard. Thank you. Any questions?
Thanks, Mr. Hopkins. That's cleared up that that issue with the dust. I just had a couple of that you referring to that condition 11B4, and you gave two. You referred to them as two small areas. Will those small areas need to be put sort of clarified in the actual condition of where practical situations could be, or is it sort of an open-ended thing?
Yeah, yes, I agree with you that the problem with that sort of wording is that it's very open to interpretation, and I think we probably could put some numbers against it. The only problem with that is obviously it's very hard to know exactly what those numbers should be until we get into detailed design. But I imagine we're talking sort of 5 meters, 10 meters with the distance from the creek. We're not talking 30 meters. So we could put some numbers against that if required. Otherwise, we could keep it as a more open condition, and that could be interpreted by the engineers at the time. Possibly best to put some numbers against that, but I'll let the planners have a think about how the plans and lawyers how they wish to approach that.
Thank you for that. I just had three clarifications from your original report. The first one was that you referred to 2 building platforms. And I understand that there's not going to be a platform around the existing dwelling, but there is going to be a curtilage area now, but no platform. But that leads on to one of your original recommendations, which may have changed, was that it was to do with the static storage tank, and that you were saying that when the platform is registered, that's when you install the static storage tank around the existing dwelling, I think it is. Has that changed now, that condition, knowing that there's not the platform around the original house?
The recommendation would always be that the existing dwelling should have suitable height. And if that means that we need to alter the conditions to ensure that before the subdivision, before 224 can occur, the suitable static storage is placed for that existing dwelling, then the condition should reflect that. So yes, it may have been an error on my part to talk about 2 building platforms, but I still think the intent is that the existing dwelling is provided with suitable firefighting would be my recommendation.
Sorry. It might just be that we just need to check that with the planners that is called up.
Ms. Afifi is gesturing to me that she has caught up with that.
Okay.
And it's in the conditions, Commissioner, but she can point that out specifically when we get there.
Okay, thank you. The second question I had was also your original report, and I just wanted to clarify, you refer to the site being 26 hectares in area, and I understand it's in the vicinity of 4 hectares. I take it that's just an error. Does that have any implications for your recommendations?
No, it does not. That is an error, my apology. No,
oh, that's okay. And the third question was just a clarification on just the earthworks. There seems to be a discrepancy on what the actual volume is. Mr. Skelton refers to 1,750 cubic metres, and I think you're referring to 1,300 cubic metres. I just want to make sure we've got the right detail there.
I would have to look back at the earthwork plans, which I believe it's the Peasant Pits Group access way plans, which will have a couple of volumes on them. I believe my interpretation was correct, but I would have to look back at the plans and check. We can confirm that in closing if that helps, but I haven't got the plans in front of me right now.
Thank you.
Thank you.
Oh, and the last question I had was just regarding Mr. Stewart, and you refer to, I'm not sure, I haven't come across Mr. Stewart, but it's just, is there anything, I'm just wondering how we take into account evidence of, I guess is it hearsay evidence of?
Yeah, I agree with you in that respect. I did. The option was there to seek formal comment from Mr. Stewart in that regard, and the decision was made to call him and have an informal discussion. If required, we could seek formal comment from Mr. Stewart, or that could have occurred, but the fact that the council engineer had not raised any concerns and essentially agreed with my original findings in my infrastructure report led us to believe that there wasn't actually too much more to be gained. That was really given, that conversation with Mr. Stewart was really given as just extra reassurance, but I didn't feel that there was a concern to be addressed in that regard. So it does leave you in a position where how do you take that information? I think it's hearsay really at the moment, because we haven't sought formal comment from Mr. Stewart, and I think that wasn't the understanding of the conversation that I had with Mr. Stewart anyway. I think he would want to be aware that that was a formal comment he was making. It was really hearsay.
Okay. Thank you.
Just a couple of brief questions. One or two of them might overlap a little bit with Ms. Baden-Hopp, so if she had better to answer that, that's fine. One of the two measures proposed to reduce, I think, nutrient load in Mill Creek, which I think has been accepted by the Lake Hayes Group, is to have a consent notice condition requiring any alterations to the existing house on Cap Lot 1 will be involve an upgrading of the effluent treatment for that. Is that just a septic tank or something at the moment, is it?
Yes, it is. So at the moment, from the original design for that, it's a septic tank. I believe it has an outlet filter on it. It's probably not a very advanced outlet filter on it, and it just feeds to a standard set of a standard trench. So obviously the proposal for the upgrade would be a minimum secondary wastewater system to modern standards.
It's basically, so I'm guessing here, 60s or 70s system that doesn't really meet what would be expected of the level of treatment that is currently were applied.
Yeah, it was actually installed in the late 80s, early 90s. It's not ancient, but primary treatment tanks are still accepted in some cases as a suitable method, but in that location, the current standard would look for secondary wastewater treatment. So there was no evidence when I was on site that system is failing, and it appears to be operating as one would expect. But yes, based on the current standard, that would be upgraded to a secondary system.
Okay. Next question. Correct me if you're not the right person to ask, but I'm interested in section 6, which is, I assume, is held in the same title as the lot 1. It's the section along Malligan's Road, which contains the ponds.
Correct.
It hasn't really come up, as far as I'm aware, in evidence, but in effect, it seems to act as a form of de facto open space. Because I understand the applicant couldn't build on it, I assume? Or anybody build on it?
Well, the applicant could get a consent to build on it. It presently houses 2 pump houses that pump water from the bore and the lakes. It would probably be unsuitable for a building platform because.
Yeah, I guess the reason I'm asking that question is that it doesn't come up anywhere, and I think it has some relationship to the issue of density. It may be of some assistance to the applicant, I'm not sure, but I'm not asking so much in the sense of needing resource consent for a substandard lot. I'm asking more in the context of, I presume somebody just can't come along with this applicant or someone in the future and say, well, I'm getting a contractor, I'm going to fill in these ponds and apply to build a house on them. Because I assume they serve some necessary purpose.
I think your assumption's right, Commissioner. It's on the same title. So it can't just be sold off to somebody else to put a dwelling on it.
Yeah.
So with typical development, it would need a subdivision consent, not unlike this application. It's 1.3 hectares, and I've been told that there's an amalgamation condition. Yeah, there was an original amalgamation condition requiring section 6 and lot 1 to be amalgamated and held in one register of title.
Yeah, because I'm just pondering, looking at, and as I say, Ms. Bard not be able to help with this in a few minutes' time, but looking at what it is, I'm not sure how it came into existence, whether those are natural ponds or someone's dug them out for landscape reasons or what the background to it is. But I mean, to some extent, if it can't be built on in the future, then effectively it forms part of an area of open space, which I guess can be taken into consideration as part of the application in terms of density.
Yes. I'm advised that the applicants are presently working with the QE2 Trust to safeguard the ponds. They pre-existed the applicants purchasing the property. They're fed by a spring on the property, but there appears to be at least some element of flows between the ponds having been engineered and been man-made, if not all of them. And they find a drain into the, as you see from Ms. Badenhoff's evidence, they find a drain into the creek. So you could reasonably, I think the conclusion from all of that is that you could reasonably treat this as long-term open space. It would seem highly unlikely that it could ever be used for anything else.
Probably a bit unfair to blame Ms. Hoppins with that question. I guess I was sort of fishing around the idea of the concept that it's, given what they do, they are spring fed, that it is unlikely that somebody could, in the future, whoever that person might be, to sort of come in and say, well, damn it, I'll fill them in and sort of try my luck in building a house on it. But that, yeah, I'm just wondering whether in engineering terms, that's really not going to be an option for anybody in the future.
I mean, I think hydrologically, that would be extremely challenging. And perhaps Ms. Badenhoff can.
Yeah, that would be very helpful.
And she's right up next, so.
Okay. Well, apart from that, my colleagues asked virtually all the questions that I would have asked of Mr. Hopkins, so I have no further questions. So I'd like to call your next witness.
Thank you. So this is Alexandra Badenhoff, the author of the evidence that's in front of you, and she's going to speak to some key points in that evidence.
Thank you.
I also just want to flag up front that I am actually a hydrogeologist, so I do have considerable groundwater expertise in the area. If you did wish to further ask questions about the groundwater capacity, that is actually within my area of expertise. So let's flag that there.
Well, while you're flagging that, I responded, I think, to that last question to say that it would be hydrologically challenging, if not extremely difficult, to put another dwelling in section 6. And can you perhaps express a view on that from your background?
Yes, so and it's just to give my understanding of the history is that the ponds were built about 20 years ago, which is what you can see from aerial photographs. The flow through the ponds is shown in, I think it's about page 6 actually. No, page 11 of my evidence. You can see that the spring feeds into pond 1, and then they are man-made between it. There is flow into pond 2, and then from pond 2 into the third and final pond before water discharges into Knoll Creek. But that it is all very low-lying and very wet. I think it would be very difficult to build on those, but also based on the limited sampling that we've completed, those ponds are fulfilling a function of improving water quality. So that issue would obviously also have to be seriously addressed if you were going to change the dynamics of those ponds at this point.
Am I to understand that the applicant is looking at or exploring the option of like a QE2 trust type covenant over that land?
Yes.
Do we know what stage that is up to, that process?
No, but we can get that information and tell you after the break.
Yeah, I think it has some relevance. It may well be of assistance to your client, but it's worth exploring. Thank you.
So a brief summary of my evidence is really to discuss the area where we can contribute to improving water quality through this development. So as a background to that, I would say that the key areas to consider are wastewater and stormwater and the existing conditions on the site. So the key areas which have already been discussed are the existing wastewater treatment system, the installation of a new wastewater system that would be required on the new building platform, which would be at a higher level of treatment than what's currently there, and also from a landscape, from a environmental landscape perspective, it is higher up on the terrace and much further away from the creek, so further from groundwater, which is also helpful. As Mr. Hopkins has discussed, we're satisfied with his evidence in terms of the attenuation of stormwater, how stormwater is being treated. So from a water quality perspective, we would consider that to be an essentially neutral contribution to water quality if those conditions are followed. So the key ways that we have discussed with the applicant about improving water quality on their sections are to improve the functioning of the ponds, firstly by removing willows, which are invasive and also contribute additional nutrients through the leaf deposition every year, and replacing those with native plantings. To improve the uptake and filtering of those ponds. That it would require the existing wastewater system to be replaced at the time the dwelling is altered or extended. That obviously isn't something that's being done now, so we haven't used that as part of the actual quantitative improvement to water quality, but that is expected in the future. So the key way that improvement will be made is through the planting addition of 2,000 plants, which we ascertain based on an approximated improvement of 100 nutrient uptake or nitrogen uptake of 120 kilograms per hectare per year at 1 metre spacing. Then the planting of 2,000 plants can offset the additional nitrogen loading on an additional wastewater system in the area on their property. And those plantings being both around the pond and in the areas of highest groundwater, of the wettest areas and along the property boundary, have the greatest ability to improve water quality outcomes, as they also take out nutrients from groundwater and also filtering runoff off the property, so reducing sediment loading and decreasing the losses of the property. So,
just while you're on that subject, statement, would it be possible to provide a plan as to where you would recommend those plantings to be located on the ground?
yes, it is possible. I did commence the process, but we decided it wasn't to be completed prior to this hearing, but yes, I can provide a plan. One thing to note in that plan is that because there is the 20-metre esplanade on either side of Mill Creek, while we would normally recommend the planting along the creek as a priority, because that's not actually on their property, that is not the area that is going to be planted, but that area will be planted through the Untitled Charitable Trust vision, that project alongside that. So and in reference to that, just around the question of water quality monitoring, That is also complicated by the fact that the esplanade isn't owned by the applicant, and therefore additional works that can be completed on that esplanade will also contribute hopefully to improving water quality, but at the moment what's happening there isn't under their control. So in terms of monitoring the water quality in Mill Creek is an ongoing way of measuring an improvement to water quality that's complicated by that process. In addition, the actual pond outlets are also on the esplanade, and there is some requirements to improve the stability of those embankments and the outlet in the future. But again, that's not on the applicant's property, so it's a little bit complicated. So in terms of it, without specifically measuring groundwater coming off their property, I think it's difficult to monitor the water quality. However, I think if you can measure the plant health and the plant, the maintenance of the plants, and that is one, it's an indicator, it's a more qualitative indicator of improvements, but it does demonstrate an uptake of nutrients and on the property. Any questions?
I've just got a couple of questions, thank you. Just on that monitoring issue, can the ponds be monitored? Like, would that be beneficial is that something that the applicant can control?
Yeah, the ponds can be monitored going forward. Again, the actual outlet from the ponds
is in the reserve
property.
Right.
However, it can be monitored. Yeah, most of the impact of the ponds will still be related to what's occurring on the property, so the ponds can be monitored.
And is that something you would support?
As a scientist, I find it very interesting. So, yeah, I think it would have some benefit. I think it also needs to be recognised that there will be in that process there will be a transition over time as willows are removed and new plants are established. So, and also there will be seasonal influences on water quality as well. So those aspects have to be taken into account when you look at a monitoring program, ensuring that the monitoring is occurring at a similar period of time each year, and the conditions that you're monitoring need to be clear about.
What I was just trying to get at is, your report, reads well and it's great. It's just making sure that actually happens out on site, and we've got the evidence to say that it is actually physically improving the water quality. It's just something, for monitoring purposes, that it's actually working for council to actually hook their staff into to say, yes, it is actually achieving what it's designed to do.
Yes. Yes.
And can I just ask a question relating to that, Commissioners? Would pond 3 be the obvious place to monitor the water from just before it flows into Mill Creek?
I would recommend that you would have to monitor the water as it comes out, as it's fed into the ponds, and then monitor the outlet as well to demonstrate that there is an improvement throughout the ponds.
Mr. Gordon, sorry, which one's pond 3?
On page, whatever I said.
Is it the one that sort of straddles the boundary with the reserve?
If you go to page 11, you'll see that ponds are identified as the evidence.
Page 11. Oh, yes, okay, yep.
And so I think what Ms. Bagenhop's saying is that the best scientific approach would be to measure or monitor the quality of water near the spring inflow on pond 1.
Yes.
And also from pond 3 near where it flows out to Mill Creek.
Correct.
Okay.
And I take it that would all be once the willows were removed and the planting was completed. There'd be no point in monitoring before that.
There is some point in terms of obtaining a seasonal baseline.
And just a clarification, I think I heard it correctly, all the planting is going to be on the applicant's site.
Yes, that's correct. So all of the planting will be outside of the esplanade, around the ponds and on the other lot, mostly in the wet areas around the boundary. The closest to the esplanade would be my recommendation.
Thank you.
Okay, well, just one, two quick questions. As I understand, looking at the catchment as a whole, which is obviously the basis of the submission from the Lake Hayes group, and I've heard submissions from them in previous hearings. The three main issues that always seem to come up are sediment, nitrates, and phosphorus.
Right.
So in this particular case, is leaving aside for a moment the issue of upgrading the treatment system for the existing dwelling, am I correct in understanding that nitrates is the primary issue that would be addressed through the proposed planting program?
The planting will uptake both phosphorus and nitrates. However, in terms of wastewater fate and transport, the main issue is more likely to be nitrate. You more commonly have a nitrate breakthrough, as phosphorus is generally adheres strongly to sediments, which is why sediment and phosphorus are tied together as an issue within Mill Creek and Lake Hayes catchments. So generally, because you have the infiltration of the wastewater through the soils, you will have more uptake of the phosphorus to the sediments. They bind to the soils on the way through, whereas nitrates are far more mobile. And so if they aren't being taken up, then they're more likely to be found in the groundwater. But the plantings do address both, and they also do address some filtering of sediments when you have overland flow across the property.
The interest is elsewhere in the catchment, is a similar approach being taken on other land?
It's still relatively new at the moment. So yes, there is a similar approach being taken in different areas, and it again, because what we're looking at is we're looking at something that's commensurate to the scale and size of any development. So it's smaller developments where we're talking about one property or an expansion of a bedroom, and most of the time those things can be addressed by some planting and protection of what we would call critical areas within a property where you're most likely to have water impacts.
Okay.
I can add to that, Commissioner, that at Millbrook, as others may well know, there's been considerable removal of willows and replanting with Indigenous species along the banks of Mill Creek. It's carefully monitored in that environment as well.
Yeah, thank you. Yeah, I'm conscious of previous hearings. The Lake Hayes group have been quite vocal about the problems that have been faced in the catchment. It's always been a little unclear what the primary source of the problem is, whether it's dwellings that are the cause of the problem that are not on a reticulated effluent treatment system, or whether it's farming activities, although there's not a lot of farming activity in the catchment now, I would have thought, or whether it's the finger of blame has been pointed at golf courses as a primary source of the problems, but whether you'd like to comment on that or not.
I think there's certainly a range of contributions throughout the catchment. So when you're talking about nitrates in groundwater, that's going to be to do with, could be to do with wastewater systems and also agricultural inputs. We're talking about sediment and phosphorus bound to sediment, then that's often going to be to do with construction, with the stream meander due to previous straightening of the channel, and as the creek sort of seeks to readjust its stream bed, with farming activities for sure, the pugging and compaction of soils in wet weather events. You get a lot of runoff of sediment, especially the perfect storm type periods are when it's been very cold and the ground is frozen, and then you have a high runoff event with some warm temperatures and you mobilise a lot of sediment across the catchment. Certainly across roads, there's a range of issues throughout the catchment, and where a lot of earthworks are completed in any one place, then you're changing the stormwater dynamics that's also contributing a lot. So where you can maintain a stormwater infiltration into soils is in natural conditions, that also provides great benefit to catch.
Okay, thank you. Do you have any other questions?
No, I don't, thank you.
Okay, thank you, Ms. Barton. That's very helpful.
Thank you.
Thank you, commissioners, and that brings us to our final witness, who is Ms. Afifi, who's prepared the expert planning assessment. And she'll come over here. This is one of the more thorough pieces of planning evidence you may have seen for some time, commissioners. At least it is for me, and we make no apology for its length. But Ms. Afifi is going to try and hit the high points and also speak to matters that have been raised in the hearing so far. So I'll hand over.
Good afternoon, commissioners.
Good afternoon.
It's ready to proceed whenever you're ready.
I think I would be best to start with the amendments that we have made to the application since notification. Mr. Hearn in the 42A reports generally recommended refusal of the application based on insufficient information available at the time of writing for a report to demonstrate that potential adverse effects on water quality and the ecological health of Mill Creek and the water lake case catchment will be appropriately avoided, remedied, or mitigated. And unacceptable adverse effects of the activity on the rural communities of adjacent residential properties due to the greater density of residential activity on site and the proximity to adjacent sites. Taking those two key matters into consideration, the changes have been summarized by Mr. Gordon previously in the legal submission, and I'll just go over them again quickly. I would also, if it's beneficial to the commissioners, read through the changes to the conditions of consent that were contained in, I think it was Appendix 8 of the 42A report. That might be helpful, and I will also answer one or two questions that came up from the younger experts. The first change to the application was the removal of the access way or the vehicle carriageway outside of the local purpose reserve to within inside the boundaries of Lot 1. Then that removed also any earthworks required for the straightening and creation of that access way within the local purpose reserve. Another change to the access way is a portion of the access way which leaves the reserve, leaves the local purpose reserve, or the existing carriageway, I should say. It comes at the eastern boundary of the application site, 2 meters approximately from the boundary of Lot 3, which is number 774A Malahins Road, estimator's property, the submission from Llewellyn and Manley, Narrowway and Manley, excuse me. The access way has been amended in that location where it is adjacent to the boundary. It has been offset an additional 5.25 meters. So the original offset was 2 meters. It's been moved further to the west to be its closest point at 7.25 meters. And that additional offset has enabled the retention of both rows of the established cypress tree hedging along that boundary. So that's the changes there, the changes to the access way. The
second key change is in respect to the boundary planting. So it's referred to shelter bales, hedging, boundary hedging. I'll refer to it as the boundary hedging just to keep the terminology consistent. The condition of consent, as recommended by Mr. Denny, is for the boundary hedging to be maintained at a height of between 5 and 7 meters in perpetuity. And that condition will be registered on the titles of the relevant lots by consent notice conditions. This is with the exception of the boundary of the southern boundary with the Bartlett property, and Mr. SP has explained the reasons for that. The boundary hedging along the southern boundary will be maintained to a height of between 3 and 3.5 meters, or as otherwise agreed on through this hearing process and by Mr. Bartlett. Related to the height, the landscaping height in relation to visual amenity matters is the reduction of the maximum building height for future buildings within the platform. There are a number of conditions applicable to buildings in the platform, and it might be worthwhile we can read through those as I go through the changes to the conditions themselves. One of those is a maximum height for buildings, and as explained by Mr. SP, the reduction of the maximum height from originally proposed, which was 5.5 meters above original ground level, which is the ground level as it exists today, to 5.5 meters above an RL of 427.
That has the effect of effectively depressing the dwelling, the back of the dwelling, into the hillside almost.
Correct. The largest effect being on the southwest corner of the dwelling. If you, we can have a look at the contours on the topographical map if you want to have a look at that. The ground levels, they vary from the northeastern corner of the platform at about 27.5 to the southwestern corner of the platform to just above 30, 430. So our condition is that the height will be 5.5 meters above 427. So the reduction will vary, obviously, as the topography dips from one corner to another corner. But overall, it's a reduction along that southern side of the platform. The remaining amendments to the application are related to the water quality matters, and also mitigating adverse effects on water quality resulting from the disposal of stormwater from the new access way. The evidence of Mr. Hopkins and Ms. Badenhop have addressed those matters in that we have a proposal to incorporate 2,000 additional Indigenous plants within both Section 6 and Lot 1. That's close to the Esplanade Reserve as is best under Ms. Badenhop's recommendations. We can go into this in a little bit more detail if the commissioners are looking for some more information or expert advice from Ms. Badenhop in terms of specific locations for those 2,000 plants. My understanding that it'll be some on Section 6 to the north of the reserve boundary, but close to the boundary, and some to the south of the reserve within Lot 1, between the dwelling and the Esplanade Reserve. So we have the additional Indigenous plants, and there'll be a consent notice condition once planted that these plants are maintained in perpetuity. And if we discuss those conditions later, we can also tighten up conditions in terms of, there is a condition regarding replacements, which is the standard landscape condition within the next available planting season. But if we need those plants to be monitored more specifically, we can look at some more directed wording for that condition. The removal of the willows within Section 6 will also be undertaken prior to 2 to 4C as part of the implementation of the landscape plan being planting of new plants, and also removal of willows. And the third method to achieve the effectively the post-development stormwater flows will have to be the same as the pre-development flows. We have the stormwater to be sent to soak pits rather than to be disposed of directly into Mill Creek. So that summarizes the main changes to the application. Would you like to go through the actual changes to the conditions and the wording?
Only where there are disputes between the applicant and the
Yes.
council.
Yeah.
I think the main concern we'd have there is where there are outstanding issues between yourself and the council. We would leave it to your discretion, but basically that's where we would see the focus as being appropriate, is where there are differing viewpoints between yourself and the council over what the appropriate conditions are.
Okay, in terms of the conditions that I have in my evidence, they are the council's recommended conditions in full. And I've outlined these conditions with changes, and they're not minor changes in terms of the council's recommendations. They're changes which have addressed their recommendations in a positive way.
So these are shown in bold underlined on.
Yes.
Yeah, okay.
These are shown in bold underlined. And then there's a full set of conditions provided. So this is they start on page 57 of the agenda, which includes the applicant's pre-circulated evidence. So these include all.
So, Mr. Fifi, following the bold underlined 4 pages, does it follow on to the full set of conditions which are based on the council section 42A recommendations, plus your 4 pages of
Yes, so the
bold underlines, and that's what you see as the full set?
correct.
Thank you.
And that full set incorporates the engineering conditions recommended by Mr. Hewlett, with the exception of the changes made by Mr. Hopkins in regard to the stormwater soak pits, which Mr. Hopkins has explained, and that's under condition 11B.
And was that the 11B for that? He was suggesting some different words for where practical.
Correct.
Okay.
Yep, that's fine.
So to summarise, Mr. Fifi, is what you're saying that there is no difference between you and Mr. Hearn now as to recommended conditions.
Correct.
Yes, and I say compared to many applications before us, there's a relatively very high degree of unanimity between the council and the applicant in these conditions. So it might be a bit easier from that point of view.
And while we're on the subject of amendments to the application, Commissioner Sinclair put the question to Mr. Espy regarding the reasons of why land use consent was removed for future buildings within the built form, within the platform. The reason for that was that previously the Chapter 24, as notified in 2019, did not contain any rules for buildings within a building platform approved after 19th of March 2019, which was the date of notification. So basically, the rule regarding control activities for buildings within a residential building platform referred to building platforms registered prior to the 19th of March 2019, which meant that regardless of obtaining subdivision consent and identification of a platform and registration of a platform on a title, if that happened post 19th of March 2019, it was a non-complying activity for any buildings within the platform. For that reason, we included the resource consent to have everything comprehensive in terms of build form and the platform, the subdivision. If we had not have done that and the rules had not changed, we would have had an approved building platform which required a non-compliant activity for any future residential buildings. So I'll add to that, those rules have changed through the appeals process. The consent status for future buildings within a platform is a control activity, and that rule no longer applies to a platform being registered prior to the 19th of March 2019. That gives the avenue for future buildings in the within the building platform to be applied for as a control activity. So therefore, we remove that application, and all buildings, all future residential buildings within the platform, and should consent be granted, will require further land use consent.
Thank you for that clarification.
And now if I could go on to the topic of lot sizes within the area, specifically to the east of the application sites. The subdivision proposes a density of 1 residential unit per 2 hectares. The site area is slightly over 4 hectares on the certificate of title. Therefore, our density overall is 1 dwelling per 2 hectares. Mr. Denny, in his evidence, does provide a plan of the nearby lots and includes the lot sizes. And that is on page 101 of the agenda that contains the council's 42A report.
Yeah. Okay.
So if we look at this plan, there's only 1 lot to the east of the application site, which has a greater lot size, presuming there's a residential dwelling on that lot, which is at 2.64 hectares. All the other lots on this map are under 2 hectares. And I'll note the Barton property is 0.77 hectares. There is another lot under 1 hectare as well. And the rest, 2 being close to 2 hectares and 1 at 1.5 hectares.
Okay, we've got that. Yeah, that was a question that we certainly had an interest in, because on the face of it, it certainly looked like the lot size was going to drop below what was typical for that area. So it's also interesting you've looked at the proposal in terms of including as part of the density assessment, if that's the right word for it, the area of section 6, which we understand would require subdivision to separate off. And if you take that into account, you end up with effectively an average of 2 hectares per lot, wouldn't you?
Yes, there's no reason not to include section 6. It's part of the application site, and It's just the fact that the creek or the reserve has split them up through the Western Reserve previously, but it is absolutely part of the application side in terms of calculating density.
Yeah, that's very helpful to have that point clarified. Thank you.
And while we're talking about the Esplanade Reserve, Commissioner Sinclair had a question regarding the route of the Queensland Trail through the lots, and that's quite simple. The trail is coming through along on the Malahins Road side of the creek.
You say the northern?
Correct.
Yeah. Is there anything further you want to add in terms of density issues at this stage?
In terms of density issues, well, I would tend to agree with Mr. Espy in terms of reliance on numbers. In that respect, in terms of densities, Schedule 24.8 and the framework for Chapter 24 for the Waterford Basin Rural Amenity Zone. It is a qualitative assessment, in my opinion, and I think the framework for the landscape character units directs us in that direction rather than a quantitative assessment of a number of them in terms of the lot areas. Saying that, I do think it is relevant to look at lot areas within the vicinity, but if we look at the lot areas here in Mr. Denny's report, it shows that the proposal is consistent with those established lot areas in the locality. The reason for that being, and historically, the sites to the east were effectively the same as the application site. They've been dissected by the local purpose reserve, and then they've been subdivided to create separate lots between those application sites. The most recent being 774A and 774 Malahins Road, which is the Narrowway and Manly property. So effectively, the application site, so to speak, lags behind in how a subdivision, in terms of the form and density of subdivision, has progressed to date.
Anything else you wish to add at this stage, or comments you want to make before I ask my colleague if she has questions of you?
Pardon, could you repeat that?
Sorry, are there any further comments you wish to add with respect to your report at this stage? Otherwise, I will go into questioning.
I'm happy to go to questions.
Thanks, Mr. Fifi. I'd just like to echo that your evidence was really thorough, and I thank you for that. Just want to clarify a couple of things, and it's going back to that consistency with those words maintained and enhanced, and maintained or enhanced, and it comes up again in your evidence where you point out that the Section 42A report refers in Section 5.2 to the environmental characteristics of the schedule of 24.8, and I've had a look at both, and the copy that I have shows maintained and enhanced, and you have told me that it should be or enhanced, and I'm just wondering, have I got the wrong version of the plan, or if you might want to clarify that at some stage. I just want to make sure we're looking at the right words. It's it's in the schedule on 24 page 5, I think. But
do you have an appeals version date on?
I'm not sure. I just had decision version October 2021. And I just want to make sure I've got the right document, because my table says and enhance, which means the planner had it right in her section 42 report, but then I'm wondering where you've got or enhanced from. So if you could just, someone guide me there on what's correct.
I will pull up the plan, but my evidence is based on the most recent decision version.
Right. So I just want to make sure if we look at it, I want to make sure I'm looking at the right words. Shall we wait while Ms. McDonald is looking at that, or should I continue?
Yeah, can I check that? I do know that this decision version has changed. I was going to ask Mr. Hearn to look, but it's actually changed in the last couple of days on the council webpage. Now it's the decision version.
Helpful again.
So,
oh gosh.
I'll
Moving feast.
Yeah.
answer that. In any case, I would note that the policy, the objectives, they talk about maintenance or enhancements, and they do not talk about maintenance and enhancements.
So they talk about or policy.
Absolutely. Yes, there's no and within the policy framework.
Okay. And it may be that the table for LCU 1 talks about and enhancements, but we'll get that clarified. Just you raise, we're looking at setbacks insufficient. We're looking at the setbacks from the boundaries, and you, in your, I think it's your evidence, you talk about policy 3.5, and you say that in your opinion, the setbacks are sufficient, but you acknowledge that the property itself will be affected. And I'm just wondering, you didn't close it off with by how much they'll be affected, whether it was moderate or less than minor, and I just wondered if you had any additional thoughts on just how much they would be affected.
Well, my evidence does provide conclusions, and it doesn't provide conclusion for every statement in terms of what had happened there, but it does provide conclusions in respect to matters such as rural amenity, which would be affected by the proximity of a building to the boundary. And in my evidence, my conclusion was that the effects on both visual amenity and other rural amenities would be no more than minor in that respect.
Just the curtilage area around the lot 2, I understand is 3,000 square meters and extends sort of as it typically would right round the back of the building platforms. Is there any thoughts on what size typically are curtilage areas, and if you reduce the size of a curtilage area, particularly around the Bartlett property, would that do to mitigating some of the rural amenity effects that they see upon themselves?
I think in terms of average curtilage areas, it might be a better question for Mr. Espy, but the 3,000 square meters was recommended by Mr. Denny, so it's my presumption that Mr. Denny has recommended the standard curtilage area for this type of rural environment. That is my understanding. Our evidence and the evidence of Mr. Espy is that the effects have been mitigated with respect to the amenity of neighboring properties. So I would say that reducing the curtilage would further minimize effects, but the evidence is that those effects are already mitigated to an appropriate degree based on the current plans. But certainly a reduction, I think, could potentially minimize effects.
Oh, just a question on The relevance still of the VAL assessment matters, are they still relevant for our considerations? Or are we moving on?
We're not fully operative in respect to the proposed district plan. The VAL sets out assessment matters for assessing subdivision with respect to form and density. This relates to the discretionary regime where there was no specified allotment size. Things for landscape character, rural amenities, etc., cumulative effects of development on the landscape. And because the PDP is under appeal with respect to minimum lot sizes with the 80 hectare regime, I don't think that the ODP and vision amenity and assessment matters can be disregarded. They're not yet inoperative.
So that is take them into account. Still, it is relevant to look at those. I just didn't hear your last part, sorry.
Yes, I believe it is relevant.
Okay, thank you. Interesting enough, the VAL matters had a specific area sort of looking at rural amenities, but I couldn't quite see a corresponding area of rural amenities in the PDP. It sort of just seems to be more integrated right through the PDP assessment. Is that in a correct sort of position there that I understand?
The PDP and the landscape character units for chapter 24 are very much directed towards landscape character and visual amenities. Rural amenities, visual amenities are a subset, a part of rural amenities overall. And rural amenity includes aesthetics and but the zone purpose and also the Malins Valley landscape units and also the policy with respect to landscape matters for in fact development within the zone. They are a little, in my opinion, silent on rural amenities in general. But you'll find that landscape character and visual amenity is stated and restated within the policy.
Right.
The framework there.
Another question I had was on just the assessment matters of the PDP, and I think originally Mr. Skelton had looked at the assessment matters of chapter 24, and then Mr. Denny considered the relevant assessment matters were more aligned with chapter 27 subdivision, and then chapter 24 has some relevance, but the main assessment matters were found in chapter 27. Do you agree with that?
I do agree that key assessment matters are found in chapter 27, but I also believe that the assessment matters within chapter 24 are relevant to the application because I think that they assist the assessment of the proposal, and that in fact is adding a second layer of assessment to our proposal. But the assessment matters provide a lot of practical type matters to look at in terms of building bulk and location, colors, landscaping, covenants, consent notices, etc. Because we've included all of those matters within our proposed conditions of consent, I believe that the chapter 24 assessment matters are also relevant to this proposal. We're proposing a building platform, yes, and there's no buildings, of course, but you can't ignore the fact that this subdivision is to provide for residential development, which is residential buildings.
Great, thank you. And also chapter 25 earthworks, I understand there is some relevance to those assessment matters for matters that aren't linked to the subdivision. There's some exceptions for earthworks associated with subdivisions, but there, to me, when I look at chapter 25, it links back to 27. Have I understood that correctly?
The assessment matters for earthworks within chapter 25 are applicable to any earthworks associated with a subdivision. So that they link to 27, but the matters within 25 are also relevant.
Okay, thank you.
Separate land use consent for earthworks within a subdivision are not required unless rules relating to volume, cut and fill, and removal of plain fill are breached.
Okay. Oh, and the last question is just the section 6. Would you support or see a need for sort of protecting that site by consent notice tool for no further subdivision and development? Is there something that we should look at, or would you be support that approach?
I would support that approach. Our conditions of consent with respect to the curtilage areas state the types of land use activity permitted outside the 2 curtilage areas. And that can apply to section 6 as well. The condition, it is intended to, the wording of the condition is not, it's not specific to lot 1 and lot 2 only. But it may be worthwhile adding a reference to section 6 if there's a slight question mark with respect to that. The consent notice will be registered on the platform, on the title of lot 1.
Sorry, Ms. Safidi, what condition were you specifically referring to there?
So if we go to page 72 of the applicant's pre-circulated evidence.
Yes.
Condition 27.
27.
Sorry, on condition 27 starts on page 70.
Yes. Yep.
The following conditions of consent shall be complied with in perpetuity and shall be registered on the relevant titles by way of consent notice part of section 31 of the Act. So condition 27. F.
Hang on, Ms. Fifi, we're lost again. I'm on 27, 27E.
Page 72.
Page 72 of the applicant's evidence. I'm just trying to find your words in perpetuity.
If we go down to condition F under E.
F, yes.
We have a condition that states the following controls shall apply to the curtilage areas on lot 1 and lot 2 identified on the landscape plan approved under condition 4. All elements outside the curtilage areas of lot 1 and lot 2 shall be maintained as pastoral grass by either stock grazing or mowing or protected landscaping in accordance with the approved plan.
We still haven't located it. We've got F1 and 2, and then we seem to go to G. Yeah.
To apply to fencing within lots 1 and 2 is G.
So F is the correct condition, and F1 and 2 are the correct conditions.
All that on domestic curtilage.
I've got the thing on domestic curtilage, and 2 relates to areas outside the gotcha, shall be maintained as pastoral stock. Great. Is that what you're referring to?
Yes.
Or protected landscaping in accordance with it. And you're suggesting in here it could be something could be added there about section 6.
Well, this condition, as worded, it does apply to section 6, but to avoid any problem with that in terms of we can certainly add section 6.
Just to make it clearer.
Yeah, I see what you're saying.
Yeah, okay. Understand.
And then that consent notice will be registered on the title of lot 1, which is section 6 will be amalgamated with lot 1.
Right, okay, that would be clearer. That was all I had, thank you.
Okay, I probably heard the discussion between ourselves and Mr. Gordon this morning, which covers a lot of the questions I was going to ask you, but as you're aware, depending on the ultimate fate of policy 24.2.1.1 and the related 80 hectare minimum, I still maintain from under the current wording, that does appear to be almost a classic king salmon type wording. Almost no flexibility written into it at all. But in your case, you have approached it on a balancing approach. For example, your paragraphs 11.7 and 11.30. So what you've done is you've looked at policies like 24.2.1.4, maintain and enhance landscape character and visual amenity. 24.215, require all buildings to be located and designed so that they do not compromise the landscape. So what you've done, you've taken policies like that and you've considered them in the round and come to a conclusion that on balance, a grant of consent to the application is appropriate on that basis. That'd be a fair way of.
Yes, and including the objective 24.2, which is for landscape character and visual amenities to be maintained or enhanced within the zone.
Yeah, okay. Just by way of clarification, through the appeal process, has anyone sought a lifestyle precinct over this area, to your knowledge?
No, unfortunately.
Okay, that's fine.
No, I don't.
Okay, no, that's fine. I don't have any further questions. Thanks for a very, very comprehensive report. Thank you.
Thank you.
Thanks, Commissioners. Well, that wraps up the applicant's case, but for our right of reply. But if I can quickly just help you with a couple of things before we take a break. And I can confirm that the applicant would be receptive to a condition as to water quality monitoring, as described by Ms. Badenhop, and it's probably somebody of her professional standing that writes that condition. So that's possibly something we can provide to you in our right of reply. Also, in relation to the conditions that she discussed, the condition is to planting the 20,000 plants and trees. We can provide a location plan in respect of that condition to give that further clarity. Similarly, the condition as to stormwater runoff can include a plan to show the areas that Mr. Hopkins referred to as being unable to be attenuated. He referred to 5 to 10 metres of the driveway where it's very close to the local purpose reserve and stream. So we can provide a small plan that clarifies that the conditions as to stormwater runoff, if you like. And the other thing that's left that I recall in our homework basket is to follow up on what the latest decisions version says in Schedule 28, is it as to and or all. And hopefully we can have that answer for you shortly.
Thank you.
Thank you.
And that completes the applicant's case. Thank you very much.
Okay, thank you very much.
Thank you.
Inclination is to take, was 1:20. If we take a break of 40 minutes till 2 o'clock, I think